Hello and welcome to this live stream, the first public live stream on the Law with Charlie YouTube channel with me, your host Charlie Metcalf. So today I'm going to be discussing the documents which have come out earlier by the government, the Courts and Tribunals Bill, and I'm going to be having a bit of a discussion about them, an informal discussion. And please, I ask that you do ask me any questions you may have, because it's much better when you do have questions. And so if you do have any questions at all, please do let me know. So I think I will probably get straight into it now. So firstly, what is it which this bill intends to do? And there's a lot to discuss. It's more than just this bill as well. There's also the Leveson report, which I might discuss briefly today in this video, but it might be, because there's so much to discuss here, it might be that I actually go and do more live videos like this as well. So it's going to largely depend on how much time I can get through today. But anyway, so one of the first things which the bill will do is to remove the right of defendants to elect for Crown Court trial in tribal either way cases. And we need to bear in mind that the main purpose of this is to try and cut down on the backlog in the justice system. However, if we're going to remove tribal either way offences, what's the impact going to be? For those of you who may not know, tribal either way means these cases can either be heard in the Magistrates' Court or the Crown Court. And under the current law, either the magistrates can send it to the Crown Court or a defendant can elect to go to the Crown Court. That's because every single criminal case, no matter how serious it is, always starts in the Magistrates' Court. And so, by taking away this right, you will see later that the legislation does allow for more powers for the magistrates, but not for the defendant, which is the first part of the government's plan to limit jury trials, because you don't get jury trials in the magistrates' courts. And so by removing the right for the defendant to elect for a Crown Court trial in a tribal either way offence, that's removing the right to a jury trial. So I think, let me just digress for just a moment. Is the fact that a defendant may be tried without a jury present, is that particularly problematic in front of magistrates? Yes, there are concerns. However, I suppose the magistrates are people from the environment. They are essentially members of the public who are volunteering, much like the jury would, and so there is a degree of similarity between magistrates and juries. However, the juries are selected randomly based on those who are registered to vote, whereas for the magistrates you have to apply to be a magistrate. You don't get paid, it's a voluntary role, and it's not always often that there's actually places around for you to be recruited as a magistrate. But we see that many people who are magistrates are usually much older, and they're often retired, which can be problematic, because that essentially just means how reflective of the people they are trying are they actually, especially how many people who appear before the magistrates are young adults with things like knife crime and so on. So that's one of my first observations. And then to come to the second bullet point, replace the automatic right to appeal to the Crown Court from the Magistrates' Court in criminal proceedings with a permission stage and replacing the full rehearing in the Crown Court with a hearing on the issues for which leave to appeal has been granted. Now, I think I'm in the middle for this suggestion. Yes, to require consent for an individual to go off to the Crown Court for an appeal isn't a bad idea. It will make sure that only those which actually have merit get to the Crown Court for the appeal. That's alright. With the full trial rehearing though, firstly, I'm not sure how common that actually is, but that's because in the Crown Court there's much more expertise around, because it's a qualified judge rather than 3 lay magistrates. So that bit could be problematic, but I can see where they are going with this, i.e. only doing it on the key issues for which leave has been granted. However, based on this little summary we've got here, it doesn't make it clear whether you can appeal on both facts and the law or just the law. If you can only appeal on the law, then I would argue that's problematic at such an early stage, because it's with the Crown Court, no, it's with the Court of Appeal, and the Supreme Court, where you're usually only allowed to appeal on a point of law, particularly in the Supreme Court. And so we need to make sure there are enough rights for the defendants who may want to pursue this route. Then if we go down yet again, introduce powers to extend magistrates' court sentencing powers up to 18 months or 24 months maximum imprisonment for single and multiple triable either way offences, maintaining the ability to vary in 6 monthly increments by secondary legislation. Now this is potentially the first real concerning point, to be honest, because, pardon me, to put this in place, i.e. extending magistrates' sentencing powers yet again, it may mean that there's going to be more higher sentences, because one of the problems with the magistrates is, in particular for strict liability offences, they can often be much stricter, and they may give a defendant a more harsh of a sentence than maybe they should have, whereas if it was in the hands of a judge, then maybe they would be more lenient if the case would allow it. It obviously depends on the crime, but I have sat in the magistrates' court previously, and some of the decisions they come out with can be questionable at times, although that's not always their fault. Much of the time it is the actual law, the law tying their hands behind their backs, and so it's up to debate whether that's a magistrate's problem or a law problem. But I do feel that when it's magistrates picking the sentence, they are less inclined to be flexible and to use their discretion to the full extent, and that might be because they feel underqualified due to not having a proper full-on legal education. But in interests of time, I'm going to now move on, and they're now going to suggest introducing a new tier of the existing Crown Court called the Bench Division to hear tribal either way cases likely to receive a custodial sentence of 3 years or less by a judge alone. Now, what are they thinking? Firstly, why do we need any additional courts? The system in itself is working, or has the potential to work, and just to put a new tier of court in isn't going to make any difference whatsoever. The problems isn't that we don't have enough courts. The problems is the government's plans which they've made in so many years. They have cut down the court sitting days. That's the primary issue, and that's in order for them to save money. But by capping the court days, there's often days where courtrooms are just sat there empty, yet we have a backlog, a rather horrendous backlog, as they keep telling us. Yet they think they need to bring in all this new legislation in order to cut down on the backlog. That's not going to work. If they really want to cut down on the backlog, then they need to make sure every court up and down the country is open every single day so they can hear more cases. Just throwing in a new court in there isn't going to make the slightest of difference. Also, this also comes down to funding. A reason why we are backlogged and the system is under pressure is because of funding cuts. And I haven't seen much here suggesting we've put more funding in the justice system, and that's problematic. If they want to improve the justice system, it's in desperate need of funding to be able to implement the changes it needs to try and tackle the backlog. And I did have another point, but it's escaped my head. But yeah, they need the funding essentially. That's it. They need the funding, yes. They need access to the courts all the time. But when I've been in the Crown Courts, and recently in the last few months on a number of occasions, it's so frustrating because none of the things that government are proposing in their Courts and Tribunals Bill are the sources of the problems. It's largely not the courts which are the problems, it's the people which make the courts work. So, counsel, so prosecuting defence barristers, in my experience, particularly prosecuting CPS barristers, not having sources ready, not having witnesses ready, etc., etc. Witnesses not showing up, so you're having to summons them to court. And even more of a problem is the court transportation scheme. So this is when defendants are being brought to court from prison custody somewhere, and there seems to be a real problem with the defendants always getting to court extremely late, even though the judge may request for the defendants to get there early. They often don't. And so this one judge I've witnessed a few times, a very useful, very good judge, he likes to start his trials at 10:15. Fair enough, more court time, arguably. However, they can't start these trials at 10:15 if the defendant is not there. And the defendant often isn't there because they haven't been transported there, or they're still in transportation. For instance, in front of this judge, there was a few situations where we were waiting over an hour for one of the defendants in one of the cases to actually show up. And so that's not a court problem, that's a transportation problem. And that's one of the many things which needs to be sorted out. Now, introduce trial by judge alone in Crown Court for suitably technical and lengthy fraud and financial cases. I can see the logic in this because these particularly complex cases can go on for weeks, if not months, and it can be very difficult for a jury to get their heads around it. However, remember, there's the presumption of innocence. Everyone is innocent until found guilty beyond reasonable doubt in the criminal courts. And so by having this rule where only a judge will sit in cases where it's technical or lengthy fraud and financial cases, this is a two-tier justice system. Are we saying that those who commit fraud and financial cases don't deserve a trial by jury? Bearing in mind that a trial by jury is a fundamental right. And so I would argue then that's problematic, because then we could have two very different cases in the Crown Court. Two people might be equally innocent. One gets to be tried by a jury, the other just the judge alone. Arguably, in an ideal world, the judge might be able to tell when there's signs of innocence, or where the guilty verdict would just be not valuable at all. However, there's been many miscarriages of justice, and so it does beg the question how confident we can be in judges sitting alone, with all due respect to judges who are professionals in their field and they try their very, very hardest in what is a system under pressure. Now, we're moving on. Introduce clearer and more effective statutory thresholds governing the admissibility of certain types of evidence, addressing the risk of myths and misconceptions influencing trials, and strengthen and clarify the operation of special measures in court. Now, that's a bit of a mouthful, and it's not explicitly clear what they really mean there. So, effective statutory thresholds governing the admissibility of certain types of evidence. So, I would say, and from my brief looks at the other areas, this is primarily focused on RASO cases, so rape and serious sexual offences. And yes, I can see the need for having effective statutory thresholds to govern these types of evidence, but again, this could become problematic when we're trying to ensure that a defendant gets a fair trial. As in every area of law, criminal law, there have been cases where men, because it is often men, well, it's only men who can be charged with rape. It's only a man who can be guilty of a rape, because to be guilty of a rape, you need to have a penis, basically, and that's what the statute says, the Sexual Offences Act. If I remember off the top of my head, Section 1 of the Sexual Offences Act. Anyway, I digress once again, but if you're limiting too much of the evidence, then that could be problematic. And a podcast which I've been listening to quite a lot, it's Rape on Trial by Dr. Candida Saunders. Please do go for a listen on Spotify or wherever you listen to your podcast, because that's a really, really great podcast. But in that podcast, Dr. Saunders talks about the issues which she comes across in these rape trials and provides academic commentary. So if you go and watch her, you will be exposed to the courtroom virtually in a way, and you'll be able to see the problems for yourself. I'm going to move on now to addressing the risk of myths and misconceptions influencing trials. Again, it looks like that's very much to do with rape and serious sexual offences. Yes, I can see again why rape myths and misconceptions might be relevant here. However, in my personal academic opinion, they're not always bad, because sometimes they can be a true reflection of what's happened. But if you go and if you go and listen to Dr. Saunders' podcast, Rape on Trial, you will see that actually rape myths and misconceptions don't really impact the jury that much. And yeah, it's not really rape myths which may mean that defendants get acquitted of sexual offences. I won't go into more detail on that, because I don't want to ruin it if you do decide to listen to Dr. Saunders' Rape on Trial podcast, which I thoroughly recommend, but she will explain it all in there. Now, this one is another one I feel very strongly about, and that's the repealing the presumption of parental involvement from the Children Act 1989 to prioritise the welfare of the child. So, for those who may not know, in the Children Act, under Section 1, subsection 2A, there's a presumption that it will be in the child's best interests to always have the involvement of both their parents in their life. That's a presumption, so that's what we presume as a starting point, but it is a rebuttable presumption. And the key here is to prioritise the welfare of the child. So, because the welfare of the child is the court's paramount consideration. But essentially, one of the arguments behind this is that by taking away that presumption, it's going to be positive for victims of domestic abuse. Now, domestic abuse is a real problem. However, in my academic opinion, just because the mother has been domestically abused doesn't mean that should automatically stop the children from seeing their father. Using the father as the perpetrator, the mother as the victim, because that's the most common case, but I do acknowledge it happens the other way around as well. But in another podcast I listened to, I think it was Pump Court Chambers, I think that might be wrong, Dean's Court Chambers it might be, it's a family law podcast, and they discussed this repeal of the presumption of parental involvement. And they said that because it is a presumption, what this reform proposes to do, i.e. take it away to protect children, judges are already doing anyway, because the judge's paramount consideration is the welfare of the child. And so if it's not in the welfare of the child to have contact with the other parent, then they shouldn't, and the judges often make that decision. And so this repeal is essentially meaningless and worthless, but I do feel that it could be problematic with them removing it, because I would argue that by removing it, that's not going to be a level playing field. Only with the presumption of parental involvement, I would argue there can be a level playing field between the mother and the father in child cases in court. That's all I will say about that now, but probably another topic of further discussion at another time. Then there's one, reform the office of the Senior President of Tribunals, bringing it into closer alignment with the leadership of the courts under the Lady Chief Justice. Now, much of this stuff which I've seen in this bill, because this is my first time looking at it, I wasn't quite aware of. It's only been the high profile problematic areas which I've been aware of, and on first read that doesn't seem overly problematic. But this penultimate one, which I have previously read, amend the provision that attaches the title of Central Criminal Court to any Crown Court sitting in the City of London, meaning only the Old Bailey will be known as the Central Criminal Court. And this is actually something I didn't know until today. And yes, I would be for that, because whenever I hear the Central Criminal Court, I do think the Old Bailey, and so for it to mean anything different doesn't really make sense to me. So yeah, I think that's a good reform. Not that there's many of those good reforms in this bill, but hey ho, I suppose you can't have everything, can you? So yeah, that's another reform which is potentially useful. Then we get to the final reform here, to make changes to magistrates' expenses, creating a power to move eligible categories for magistrates' expenses to secondary legislation. And I don't see much of a problem with this either, because by moving it to secondary legislation, it would allow more flexibility, meaning changes can be made much more easily, which is problematic if they're going to remove expenses or make it less advantageous to magistrates, but it's going to be better if they're going to allow better expenses schemes. Now, just going through this list here and having a discussion has taken me much longer than I thought it would actually, and I don't see any chats here sadly, so there's no questions for me to ask, which is a real shame. But I'm going to leave this live stream to be public even after it's live, and so if you do have any questions at all, please do let me know. Now, as I was saying, this has taken me much longer than I thought it would, and so I didn't want to make this live too long, and so I'm going to end it in a moment. But I'm thinking that maybe it will be useful if I do more lives like this, maybe every Wednesday evening or something, half an hour, informal discussion with me, and that might give me some time to get through the various aspects of this major reform. So just to go through it, this is the main part of the bill where it's all detailed, and so it's had its first reading today, i.e. its title has been read out, and now we're waiting for the second reading to be announced. But this is the bill itself, so there's 100 pages to this bill, and there's a lot to go through, so it would be really good if I am able to go through this at some point in another video. Also, in another video, I do want to look at the Leveson report, which is really the report which has really actioned this reform which we are seeing in this Courts and Tribunals Bill. So this is just a summary which I won't go through, and it's split into two parts. So this is part 1, then there's also part 2. Part 1 was published in July 25, whereas part 2 was published, I believe, earlier this month, February 26. And these quotes here are extremely important. Justice delayed is justice denied. When justice sleeps, justice is cancelled. To delay justice is injustice. Justice too long delayed is justice denied. And to no one will we sell, to no one we will deny or delay right or justice. That was from Magna Carta, which doesn't really have much bearing in the modern age, but I think those quotes really establish how fundamental a working justice system is, and we should bear those quotations in mind whenever we're discussing these reforms. But in the Leveson report, I will just go through the key chapters now, and then these will be things which I will discuss in more detail in the future. And so I'm going to go actually to the part 2 of it, because this one provides a better outline of everything. So this is volume 1 of part 2, and this is really the area which I want to focus on, and particularly the matters of remote participation, hearing processes to an extent as well, and preparing for first hearing and ongoing case management also sounds quite interesting. And this is those areas in a bit more detail. So there's a lot to discuss, as you can see. One of the things which I have a particular research interest in is remote hearings, and so I do think that's going to be a whole video, if not series, in itself. And there's also a discussion of making more use of AI in the system as well. But I'm not going to say anything more now. I will end this live video here. Thank you all for watching this, whether live or on playback. Any questions, please do put them in the chat. And make sure you like, comment and subscribe to my channel. Like my videos. If you subscribe, you'll get notified when I'm doing more videos like this. And ultimately, I look forward to talking with you again very, very soon, and hopefully some more live streams, because I think this is a really good way to get to know my audience a bit more. And also, yes, you may have subscribed to my channel, but if you haven't checked out my podcast already, go check out my podcast, Law with Charlie. You can access that both on my YouTube channel, but also you can find that on Spotify and wherever you listen to your podcast. But that is all from me today, and I wish you all the best, and I will